I wanted to welcome everyone to this webinar and our Denton's ESG Climate Change Litigation and Disclosure Requirements Seminar on recent developments in Canada. Before we get started, I just wanted to cover a few housekeeping matters. Firstly, I'm Tom O'Leary, and I'll be introducing our other panelists in a moment. The housekeeping matters, for accreditation purposes, this session is eligible for 60 substantive minutes with the Law Society of Ontario and British Columbia for continuing education credit. The session also meets the CLE requirements of the Barreau de Quebec, and the contact email will be provided in the post-event email to receive a certificate in that respect. If you do have any questions as we go along that you'd like to address to the panel, please feel free to submit them through the session via the Q&A function, and we will do our best to address them at the end. We also encourage you to subscribe to our blog and podcast for latest updates. The details for that can be found in our website and will also be shared in follow-up emails when the materials are distributed. Please also note finally that we're being recorded, and that recording will be made available in the post-event email and on the series page for those who want to share it or review it. On to introductions. I am Tom O'Leary. I'm a senior partner in our litigation and dispute resolution group in Calgary. My practice focuses on commercial disputes, including contract, securities, and real estate related disputes. I'm joined today by two of my colleagues, David Conkin and Kelly Osaka. David's an associate in our Calgary office, and he's also a member of our litigation and dispute resolution group. David acts across Canada on a variety of administrative law, regulatory, class actions, corporate disputes, and government investigations. I'm also joined by Kelly Osaka, my partner here at Denton's, and she is the co-lead of our litigation and dispute resolution group in Calgary. Kelly has particular expertise in class actions, shareholder disputes, privacy law claims, and regulatory investigations. Today's webinar focuses on climate-related litigation and class actions against private companies. We'll address key questions relating to liability for climate-based damages, including justiciability of central issues of civil responsibility in the Canadian context. I will now pass the baton to David Conkin, who will discuss public interest litigation as the first section of our webinar. Take it away, David.
Thank you, Tom, and thank you everyone for joining us today. When we're talking about public interest litigation, just briefly, this is largely, it's a new area that is seeing individuals suing governments, including by class actions. And the primary goals in this area are to compel government to take more aggressive action to combat climate change, largely through greenhouse gas emissions reductions, stricter regulatory regimes, or say denying approvals to projects that are greenhouse gas intensive. This is a new area of environmental litigation that's really come up around the world. We're seeing actions that are brought under constitutional rights, under torts, nuisance, trust, various civil rights. And it's really just an area that has grown hugely, is in almost all countries. You'd be surprised at the breadth of which these are proceeding, and certainly not just in Western countries. One of the cases that has been successful in this area was actually in Pakistan. So where some of this sits is that there are a number of countries, and 90 countries, that have some recognition in their constitution of an environmental right. And there are other countries that don't have this explicit recognition, and Canada would be one of those, where litigants are attempting to use rights such as a right to life or security of the person to find a way to compel government action on climate change, or more aggressive government action, or to at least get government to stop actions that they view as increasing greenhouse gas emissions. Now, the really seminal key case in this area, which many of you may be aware of, is out of the Netherlands, and it's the Urgenda Foundation. And this one is a constitutional case based on the European Convention of Human Rights, and it focused on two of those rights: the right to life and the right to the respect for private and family life, home, and correspondence. Now, keep in mind here a moment on the right to life. The actual phrasing in the European Convention on Human Rights is everyone has a right to liberty and security of the person, which may sound familiar in a Canadian context, and we'll get to that in a moment. Another very recent case on this comes from the German Constitutional Court, just from this summer. And the German Constitutional Court, they declared that the Climate Protection Act was unconstitutional in part because it breached certain fundamental rights to freedom by not providing for reduction targets beyond 2030 until the point at which the German state had reached net zero. There are some interesting aspects of this, and where the German Constitution provides not for a right, but perhaps more of a procedural protection in a way, requiring the state to protect the natural foundations of life and animals for the benefit of future generations. So tying that provision in with the right to freedom, the court found that there was an obligation on the German state to take action beyond what it had already planned on doing up to 2030. And it even takes on an international dimension in this, and saying, the court saying that the state's compelled to take internationally oriented activities, not just focused on Germany, in order to tackle climate change at a global level. So this is one of those, these cases that is pushing the boundaries of where the law sits right now on taking fundamental rights that we're quite familiar with, such as life, liberty, security of the person, and finding an environmental aspect to that, and in the German case, finding an intergenerational aspect to that. So where are we sitting in Canada on this? Well, we've started out with a Parliament adopting a motion declaring that we are in a climate emergency, and Parliament supporting Canada's Paris Agreement targets. We're continuing to see those targets become more aggressive. And then the most recent statement from the Supreme Court of Canada on environmental law is involving the Greenhouse Gas Pollution Pricing Act, or as may more broadly be known as the Carbon Tax Act challenges. And in these, the government of Canada was putting forward significant evidence to justify its position that it had constitutional jurisdiction to bring in legislation that could apply across Canada and regulate matters that the provinces or certain provinces were saying fell within their jurisdiction. But in the course of the majority making its finding that the federal government did have that constitutional jurisdiction, it made certain findings that, in my view, are going to be relevant to how the courts continue to approach these cases, and we'll delve into a couple of them in just a moment. And you see here on the screen, that the court is talking about negative effects on human health, including morbidity and mortality, and also about floods, forest fires, reduced rainfall, degraded soil and water, heat waves, sea rise, and a spread of life-threatening diseases. So certainly, this is a reference case. It's not binding on anything. Findings of fact in one case aren't necessarily going to apply or be found in another case. But and this is the statement coming to the Supreme Court of Canada that it's providing some of that basis for which plaintiffs are bringing claims. If we go to the next slide, please. So there are 4 main cases being advanced in Canada right now. Starting at your top left here, the Loimgin and Canada case. This is a claim brought by 2 Wet'suwet'en houses against Canada, and it's based on the allegation that Canada is taking insufficient action to combat climate change, that its greenhouse gas reduction targets are insufficient, and that it's failed to use its discretionary decision-making power under environmental assessment legislation to deny approval for greenhouse gas intensive projects. Now, this one is a little bit different from some of the others. It has an Indigenous angle, whereas most of the claims that are being brought are actually being brought by youth. This one, Canada brought a motion to strike in the federal court, and the federal court has granted that motion, finding that this is greenhouse gas targets are not a justiciable matter. It's instead something that's inherently political. Now, the plaintiffs have appealed this to the Federal Court of Appeal, and that's currently outstanding. The case of the top right, Environnement Jeunesse, this is the first case that we saw in Canada. It's a class action in Quebec against the government of Canada, and it's focused on youth plaintiffs and the impacts of climate change on them. This failed to be certified. That's also under appeal. Really dove into some of the key aspects of the certification test, including that there was an arbitrary distinction, finding that those under 35 were proper members of the class. The 2 cases that I really want to focus on here are LaRose and Mature. So if we could move to the next slide, please. And what these cases are really getting at, the key question that we're focused on at this stage, before we get into even the proving what Canada did or didn't do or what its specific obligations are, is whether these claims are justiciable. Now, it's a particularly interesting question because these 2 cases have so far played out differently. In Ontario, Mature, this one is focused primarily on Ontario's repeal of the Climate Change and Low Carbon Economy Act. It's a charter challenge. Ontario brought a motion to strike, and the Ontario Superior Court dismissed that motion. So this one is proceeding. On the other hand, we have LaRose in Canada. So a federal court of Canada claim against Canada, not focused on a particular piece of legislation like Mature is, but instead focused on the broad acts and alleged failures to act by the government of Canada, and that impact of that on climate change and the youth plaintiffs there. This one, the federal court granted a motion to strike, and that's also being appealed, in this case, to the Federal Court of Appeal. So, it's this question of justiciability that is animating both of these cases, about whether the matter has a legal dimension, whether this is about constitutional rights, or whether we're dealing with a political matter. And one aspect of this is whether, and this is a bit more alive in LaRose in Canada, about whether governments have this obligation to take actions to prevent charter breaches. Now, we do have an example of that in Canada, of where charter right to French language education was found that Nova Scotia was not taking steps to build French language schools fast enough. And so the court jumped in and said, you need to do this. And the trial judge, upheld by the Supreme Court of Canada, actually took ongoing carriage to hear reports on the progress that Nova Scotia was making in order to meet what had been found to be its constitutional obligations. So it's this question of justiciability is the stage at which these claims are being fought right now in Canada. But the next stage that we're going to be coming to is where these claims are have found themselves in the Netherlands and in Germany about whether these charter rights can actually provide a basis for plaintiffs to force government to take more stringent action against greenhouse gas emissions. And if we look at some similarities of, say, the right to life and security of the person that we're seeing between these constitutions, there is a prospect that we may see this in Canada. There certainly are differences, and this is going to be a very fraught question in terms of how the arguments are made. But plaintiffs are already relying on these international cases in their arguments before the Ontario and federal courts. So we don't know where this is going yet. Certainly, I think decisions in the Netherlands and Germany came as a surprise to some. So an area we're watching intently, we'll be continuing to analyze. And that brings me to the end of my presentation on public interest litigation, but certainly if later on, if there are any questions in our Q&A, I'm happy to reach out to those. Thank you.
Thanks, David. So I will be looking at private sector climate change litigation. And I think it's helpful to take a step back and look at the fact that there have been a significant increase in climate change cases, both in Canada and internationally, since 2015. So there have been over 1,500 cases, both ongoing and concluded, that have been filed. The majority of those have been in the US, but also internationally. And these cases are being tracked by Columbia Law School, which maintains and international proceedings. So if you haven't had a chance to check that out, I suggest you do. It's very user-friendly. And as we've heard from David, most climate change litigation claims are brought against government, but we've also seen an increase in these types of actions brought against private organizations. So we have the more traditional claims against companies, and that would be against specific companies or industries where individual litigants are seeking to establish corporate liability and to recoup damages to pay for example, infrastructure improvements, which they have alleged that they will or have incurred as a result of climate change. And one type of this more traditional climate change litigation that we've seen is in the US, with municipalities suing the energy industry in this regard. So for example, the city of Baltimore sued 26 oil and gas companies in 2018, arguing that they were liable for the city's costs in dealing with extreme weather events, as well as public health risks as a result of climate change. Other lawsuits, similar lawsuits, have been filed by municipalities in 20 other jurisdictions in the US, including Massachusetts, New York, Colorado, and California. So the defendants have tried to move these proceedings from state court to federal court, and they argue that emissions and climate change matters are national matters as opposed to at the state level. The defendants generally prefer federal courts because of a unanimous 2011 Supreme Court decision, which found that under federal law, the Clean Air Act displaced common law nuisance and gave sole jurisdiction to the Environmental Protection Agency in that regard, obviously disrupting the plaintiff's ability to bring claims in that regard. So earlier this year, the defendants in these municipality litigations were successful before the Supreme Court in obtaining an expansive review of issues in determining whether the cases should be heard in state court or in federal court. So that was a fairly technical victory for the defense groups. There has not yet been any decision on the merits. We're still keeping an eye on that. So as I said, those are the more traditional claims that we've seen brought against corporations. What we've also seen, though, is this trend towards strategic litigation. And by that, I mean the purpose of the litigation is beyond resolving issues that are directly between the parties. Instead, claimants are attempting to influence corporate behavior in regards to climate change reduction targets, or they're simply trying to draw attention to what they perceive to be large emitters. So one example of this type of strategic litigation would be in greenwashing cases. And this is where claimants will often accuse companies of misleading or overstating public announcements on corporate actions taken on climate change or green initiatives. An example of this type of strategic claim was the state of Minnesota bringing a claim against Exxon and Koch Industries, as well as the American Petroleum Institute. And there the state is alleging fraud, misrepresentation, and deceptive trade practices, and alleging that the defendants undermined the science of climate change and purposefully downplayed the role that the purchase of their products played in causing climate change. The state is seeking, amongst other things, disgorgement of profits from this alleged unlawful conduct. So that's an example of, as I said, greenwashing case. The other type of strategic litigation that we have started to see is claimants seeking to recognize corporate responsibility for human rights. And that brings me to this Shell decision that came out earlier this year. Go to the next slide. So the Shell case is one that I'm sure you're somewhat familiar with. It was a litigation brought by 7 Dutch NGOs and over 17,000 individual claimants against Shell. And at issue was whether Shell had an obligation to reduce its emissions through its own corporate policy. So specifically, the claimants in this case argued that Shell had an obligation arising from an unwritten standard of care under the Dutch Civil Code to reduce its emissions. And the claimants were successful in a May decision from earlier this year before the Hague District Court. So in that decision, the court considered several factors, including the UN guiding principles on business and human rights. The court also wrote that it considered the twin challenge of curbing dangerous climate change and meeting the growing global population energy demands. The court also considered the onerousness for Shell to meet the reduction obligations. So considering these factors in the final decision, the court did not find that Shell had actually acted unlawfully, but instead ruled that the company did have this obligation to reduce its own emissions, and it had a significant best effort obligation to reduce emissions along its entire value chain. So that means both suppliers and the end consumers. The court ordered Shell to reduce its CO2 emissions by 45%, and that is from 2019 levels. And it has until the end of 2030 to do so. Finally, the court determined that the goals of the Paris Agreement, which David spoke about earlier, which is basically reaching global net greenhouse gas emissions of 0 by 2050. So the Paris Agreement is relevant to the determination of Shell's obligations to reduce its emissions. That's a summary of the decision. Shell has since announced that is appealing the decision. Insofar as why this decision is significant, it is the first time that the effect of climate change on human rights has been successfully argued to require a private organization to reduce its emissions. It's also the first time that court has ordered a private organization to reduce its carbon emissions in accordance with the Paris Accord. So although the decision is based on Dutch law, the reasonings were grounded in international standards and may be applicable on a more global scale. And obviously, while the decision is not binding in Canada, it may influence companies' decisions in regards to reporting on climate change related risks to mitigate against future lawsuits such as this one. So that is the Shell decision. And that brings me to where are we at in Canada as far as these types of climate change litigation being brought against private organization. And what we know is that Canada has not yet experienced the same level of climate change litigation against corporations that we've seen internationally and in the US. There hasn't been any strategic claims brought against energy companies seeking to reduce emissions through claims of corporate liability or failure to disclose or misrepresentations. There have, however, been some nascent signs that this type of litigation may be coming to Canada. The first part of that would be the Lytton class action. So as I'm sure you're aware, this summer, BC experienced horrific forest fires, one of which caused the destruction of the majority of the village of Lytton. In August of 2021, class action was filed in British Columbia by the residents of Lytton against 2 railway companies for allegedly causing or contributing to the wildfires that destroyed the village. The proposed class action makes claims in negligence, nuisance, and strict liability against the defendants for continuing their train operations while Lytton was facing record high temperatures and while forest fires were burning in the area. Specifically, the claim alleges that the defendants had been notified by the province of the extreme risk of wildfires and were aware that sparks from the train operations were likely to cause harm due to those conditions that existed at the time. Now, this is a very new claim. Obviously, it has not been proven in court. And in fact, the claim has not gone to a certification hearing yet. However, it is of interest to businesses in conducting their own risk analysis regarding climate change and operations. So that is one of the examples of the strategic claim brought in Canada. We also have been hearing some noise from municipalities that there may be claims coming similar to those that I was just describing in the US. So Victoria became the first municipality in Canada to vote to endorse bringing a class action lawsuit against oil and gas producers for climate change related harms. The Victoria City Council resolved to support a class proceeding, and it asked the Union of BC Municipalities to examine the possibility of launching this type of lawsuit. At the following meeting of the BC Union of Municipalities in September of 2019, the Victoria City Council's motion, as well as the City of Port Moody's similar motion, were denied. However, despite the fact that these motions were voted down, some BC municipalities have continued to express interest in putting pressure on the BC provincial government to bring a climate change related action against emitters. So similarly, in April of 2019, the City of Toronto's Infrastructure and Environment Committee passed a motion that directed the city to consider suing greenhouse gas emitters for damages in adopting and repairing costs related to climate change. Again, none of these lawsuits have actually been commenced, but it is something to keep an eye on as far as Canadian climate change actions go. This takes me to the last slide, and this is in regards to corporations suing government entities as a result of climate change policies. So not all climate change litigation is directed at strategic reasons to reduce emissions. We have also seen an increase in lawsuits brought by corporations suing governments for compensation for future losses caused by the introduction of climate change policies. One example of this is in the RWE versus State of Netherlands case. And there, a German energy company, RWE, brought a claim for compensation against the Dutch government following its announcement that it was going to phase out coal power plants by 2030. So the German company alleges that that policy amounts to expropriation of its investment in a coal-fired power plant, and that it violated provisions of an energy-related treaty to which the state was party. So these cases are often determined in arbitration, and that risk of an arbitral award could impact the implementation of climate change regulation by policymakers. Another example of this type of litigation where corporations are the ones suing governments is in the denial of permits. And this occurred in California this year when the media reported in November that California regulators had not approved permits for fracking since February of this year, which effectively phased out the process ahead of the state's already declared 2024 deadline to end fracking in the state. So the state regulator, according to the media report, had rejected an unprecedented amount of 109 fracking permits in this year alone. And many of those permits were denied because based solely on climate change concerns. So as a result, an oil industry trade group, the Western States Petroleum Association, filed a lawsuit claiming that the state's denials of fracking permits were outside the administration's authority and an abuse of its discretion. The claimants also asserted that by increasing reliance on imported oil from overseas resulted in negative effects on climate change, including increasing the risk of spills. So this type of denial of permit litigation has also been started in Canada, and one example of that is in Quebec. In September of this year, the Quebec government was sued by Utica Resources for its plan to ban oil and gas production in the province. The Quebec government had announced that it will stop issuing permits for exploration and drilling. Utica holds 31 exploration licenses in Quebec, and it argues, similar to what we saw the argument was in the German case, that the Quebec's government's policy constitutes a form of disguised expropriation. And Utica is seeking billions of dollars in damages as a result. So these cases of corporations suing governments show that climate change litigation also can impact policymakers in considering economic interests instead of solely the reduction of emissions when implementing climate-related policy. That is my summary of where we're at as far as climate change litigation against private organizations. I will hand it over to Tom to discuss disclosure requirements.
Thanks, Kelly, and thank you, David. The third important area of liability exposure in terms of climate litigation is what I'm going to discuss, and it involves corporate disclosure of climate-related risks. And if you could advance the next slide, please. Kelly and David both mentioned some of the very considerable obstacles to success in public interest type litigation and in other types of private claims. Those include certainly high costs, justiciability challenges, causation challenges, as Kelly referred to, and the availability of compliance defenses as well. Because of these sometimes daunting obstacles to success in those ambitious types of claims, increased attention seems to be gathering and directed toward using disclosure-based claims as a vehicle for strategic litigation aimed at minimizing climate change. I think it's fair, and I've not sure I've heard the phrase, but certainly the sentiment that this type of litigation, while it's not as ambitious in terms of the remedy it seeks as you would have in major public interest action or an action seeking to assert causation of climate change against particular parties, it is somewhat low-hanging fruit in other respects, in that it doesn't face some of those significant obstacles that you would face bringing other kinds of claims. Essentially, it's part of a long game to alter corporate business and political culture, which is hoped by its proponents would have a long-term effect of significance. Disclosure requirements certainly can arise through general tort law, consumer protection law, and under existing legal frameworks, corporate and securities law as well. But today I want to focus on climate disclosure requirements in those latter contexts, corporate and securities law, and in particular on some recent developments and the effects they may have going forward. As many of you, I'm sure, are aware, over the past decade or so, there's been concerted lobbying efforts by NGOs and other groups to compel corporations to disclose information about the impacts of their activities on climate change, and also about the risks to their businesses that exist due to climate change, both now and on a forward-looking basis. The stated assumptions behind these efforts are really twofold. The usual stated one is that these matters are relevant to the financial performance of the business and will impact by that mechanism share, asset, and enterprise values. Less often stated, but I'm going to suggest also assumed in this respect is an assumption that's a little bit more unique, and it goes with the concept of stakeholder capitalism that has been advocated by various influential business leaders and political leaders, Mark Carney being one obvious example. And that is that the purpose of the corporation goes beyond creating a value for the shareholder, but creating value for the broader society. And this leads to the assumption that the decisions of investors, of customers, of lenders to a business don't simply make financial decisions, but their decisions are also made, at least in part, on non-financial grounds generally, and more specifically on grounds of climate impacts and climate risks that the business may be involved with. A watershed moment in these efforts and in the development of disclosure requirements on climate change was the 2017 report of the UN Task Force on Climate-Related Financial Disclosures, or the TCFD, as it's often referenced in literature. And this report sets out a variety of recommendations on importing climate change-related reporting into securities and corporate law. It would include, according to those recommendations, reporting on the contributions of the business's activities to climate change, the risks that presents to the business, and the opportunities that might arise from it for that business. The task force recommendations were intended essentially to be a model for legislation and regulation in member countries. It's taken a few years, but within the past year, the U.S. Securities and Exchange Commission has undertaken an initiative toward establishing formal climate change disclosure requirements. And in Canada, the Canadian Securities Administrators, just in the last month or so, have recently published proposed climate disclosure requirements for public comment. Those requirements are heavily based on the task force recommendations. And if we go to the next slide, please, the proposal of the Canadian Securities Administrators, or the CSA, involves 4 aspects of reporting specifically. And again, this reflects the UN task force. The first involves governance. That is the nature and extent of the board's and management's oversight of climate risks and opportunities. Second, reporting on strategy in both the short medium and long terms to manage climate change risks. Thirdly, excuse me. And before I get to risk management, actually, there's an important departure in the CSA recommendations from the UN task force recommendations, and that is the lack of any scenario specific strategic reporting requirement. And by scenario specific, I mean that the task force recommendations were to require issuers to report on what strategies would be with an under 2 degree change in global average temperatures to 2050 and above 2 degree change as well. Whereas in Canada, that recommendation was not included in the CSA report. And the third element of reporting now likely to be required based on the CSA report refers to risk management, and that's the processes for identifying, assessing, and managing climate risks. And also how those processes are integrated into the broader risk management framework being utilized by the business. Finally, there's a requirement to report metrics and targets for assessment and management of climate risks. And this is really kind of a threefold piece. The metrics used to assess the climate risks are to be set out specifically. The GHG emissions of the business itself and those related to the business, that is direct emissions from its operations, the upstream emissions that are connected with operations, as well as the downstream emissions that flow from operations, are all required to be reported based on this proposal. And the third aspect of the metrics and targets needed that are to be required reporting are the targets used to manage the risks and assess the performance of the business's strategy and tactics against performance of these. And this would include minimizing GHG emissions of the business itself, of course. The effect, I think, self-evidently will be to standardize the extent and nature of the disclosures required. And moving to the next slide, as again, most of you know, and I mentioned mounting pressure for many years, even outside the use of formal requirements for issuers in Canada and elsewhere to report on climate change risks and activities. This has been not only at the shareholder level in terms of shareholder initiatives to use the voting power of shareholding to modify company behavior, but also in a number of legal actions, but those generally have been, in fact, entirely have really been outside of Canada. Despite all these efforts, there hasn't really been a clear or widely accepted level or standard for reporting that might be required. There are various publications that suggest one standard or another, or one pattern or another of reporting, but none seem to have been adopted as an industry standard in any formal or even informal way. That purpose of formalizing and standardizing is what the CSA proposals are really aimed at. And if you're moving on to the next slide, the broadened and clarified disclosure that would result from the CSA proposal, I suggest will have the possibility of very significant impacts on litigation risks faced by Canadian companies. I think it's self-evident that more broader, deeper disclosure requirements will broaden the risk of litigation. That is, the more information that must be reported, the greater chance there is that the information will be found or accused of being wanting in some respect. On the other hand, with clarified disclosure requirements and standards, businesses have the opportunity to better manage litigation risks related to disclosure. Of course, the X factor, as always, real world impacts and events and socio-political forces can also have a significant effect on litigation risk related to disclosure. Careful scrutiny in particular, and this is from a number of different articles that talk about what might be ahead. It seems to me that the consensus is that disclosure of climate-related risks and the scrutiny that will be given to them by activist investors, by regulators, by strategic litigants, will probably focus on a number of items which are at the right side of the slide: supply chain and operational disruptions, the risks of those, the environmental compliance costs and non-compliance liabilities that exist now and may exist if regulatory controls continue to evolve as they have, expanding and becoming more and more onerous in this area. Reputational impacts due to the conduct activities of the company involved, but also due to climate risks themselves and the exposure to that. The ability to access capital can be affected also, both by reputation and other aspects of risk. BlackRock famously is seeking to divest itself of fossil fuel investments as an example of that type of challenge or risk that may be faced by a business. And finally, that particular industries and sectors are made perhaps more or less sensitive to these various risks. An example is the oil and gas business, not just reputationally, but 86% of refining capacity in North America is located within 10 feet of the nearest high tide level, and rising sea levels presumably would significantly impact the risk to those operations. These risks, I think, again, self-evident, may not be very easy to identify and assess on a prospective, forward-looking basis. And the limitations of that forward thinking alone suggested multiply or enhance litigation risks associated with disclosures. If I can go to the next slide, please, Janelle. So the forces, to summarize that, the forces multiplying or exacerbating litigation risks. We have the trends of climate issues having an increased influence on share, asset, and enterprise values, and the trend of an increased focus on disclosures as a vehicle for strategic litigation. The Exxon experience in the United States is a bit of a bellwether and example, as Exxon seems to be the primary focus of these types of claims, at least in these early days. The attorney generals in both New York and Massachusetts brought claims against Exxon regarding misleading investors through their disclosures about their role in climate change and causing climate change. The New York action was dismissed on the basis that disclosures weren't misleading, and even if they were, there couldn't be any investor reliance proven. Whereas the Massachusetts action survived these preliminary arguments to strike, at least thus far, and is ongoing. Another avenue has been the investor class action, and in Texas, class action was brought against Exxon on this basis, again, alleging securities fraud about misleading climate-related disclosure. That case too is ongoing. And the next slide talks a little bit about the situation in Canada, such as it is. There's really only one instance of this type of disclosure-related litigation or related claims that we've been able to locate, and that involved Kinder Morgan, as famously building the Trans Mountain Pipeline. In 2017, Kinder Morgan issued an IPO to raise money specifically within a vehicle for the expansion of the pipeline. Greenpeace lodged a complaint with the Alberta Securities Regulator to pause this IPO on the basis that it did not properly disclose climate-related risks that were required to be disclosed. The Securities Commission in Alberta here agreed to review the complaint, but the results were never disclosed, as Kinder Morgan responded by reissuing the IPO with some supplemented or additional disclosure. While the case didn't result in any decision or any particular resolution, it does illustrate another potential approach to impugn climate risk disclosures that might be taken, and a risk that should be considered. And moving on to my last slide, where are we now? You see the Supreme Court of Canada there photo, which is where these things will someday, at least some of them will almost certainly end up. The trend that seems to be clear is that more disclosure-related climate litigation can be expected in Canada, both as a cause of the seemingly pending specific disclosure requirements to be implemented, but also those being the symptom of the same forces that will enhance those litigation risks related to disclosure. The broad scope of the proposed requirements extends far beyond the energy sector. Certainly pension funds are investors that will be carefully scrutinized for compliance with disclosure requirements. The power sector will be another area that one would expect to be carefully scrutinized in terms of involvement in renewable energy, minimizing emissions, and in terms of up and downstream related emissions. The risks don't just involve civil claims, but enforcement actions, regulatory complaints, class proceedings. All of these may be available for breach of disclosure obligations. The precedents of effective tobacco and asbestos litigation strategies based on non-disclosure are certainly held up within the environmental movement as roadmaps, as it were, for climate-related litigation against energy producing entities in particular. The specific disclosure requirements give these types of claims, regardless of the form, some definition, some actual requirements, rather than just a vague requirement of material disclosure that claimants can cling on to. And that would seem to remove at least one barrier to these types of litigations, a barrier of uncertainty as to what exactly is required in material in the eyes of the court. Finally, the litigating on disclosure requirements, as I mentioned earlier, does allow strategic litigants to bypass some of the more daunting challenges of politically more ambitious types of claims based on public interest or private litigation, which try to attribute climate change costs and impacts specifically to industry. So those are my remarks. And I'm going to just take a look now and see there don't appear to be any Q&As posted yet. But we have a few minutes, and maybe I'll start with one question that I wanted to ask David about justiciability, intersection with the idea that the charter rights can compel positive actions right up to obligation to legislate on governments. Is there any room left for justiciability issues if the idea does indeed take hold that charter rights can require positive actions by way of legislation for governments? Doesn't that sort of answer the justiciability issue all by itself?
Not fully. Certainly it deals with one of the key questions on whether we're dealing with a positive obligation to act in order to protect constitutional rights, but it still leaves a dimension of that question on whether it is a political question on what what government actually has to do, or whether the court's in there to review the actions or non-actions of a government in determining whether it is a breach. So I think that, Tom, that's exactly out of where this is going to be fought out at the appellate level now that we've seen a couple trial court level decisions. But no, I would say justiciability is not fully settled on this.
It certainly seems to be an issue that's been brewing or simmering for really since the charter was enacted in different contexts, and is one I think it's probably fair to say is fraught with peril on both sides. There is a question I want to that was from Benoit Pepin, which I think is probably better directed to Kelly, and I'll do that. As a consequence of the private litigation, such as the Shell decision, do you see voluntary corporate policies and abatement commitments becoming binding in court proceedings?
Yeah, I mean, I could see that as being used as evidence for any final order that a claimant may be seeking as against a specific company. But I think what the Shell decision also showed us was that the court was more comfortable in the international standards set and agreed on, whether those were from the UN or the Paris Accord. And that's really where we saw the court ground its decision and end up with its final numbers. I don't know what your thoughts are on that as well.
It's certainly in the context of disclosure, the entire idea of the CSA report and the UN task force recommendations is indeed to make those binding in court proceedings, though perhaps in a different context than the type of litigation you're speaking of, but in a one-on-one type of investor claim or other claims. That's the entire idea and goal. It may or may not be transferable to broader, as I say, more ambitious private litigation claims. All right, well, those seem to be the questions that have been proposed for us. I wanted to thank all of you for being here with us. It's been a pleasure for Kelly and David and I. And if there are matters arising that one or more of you think of later, please feel free to address them directly to Kelly and or David and or me. And we will do our best to make sure we address those for you and respond. As I indicated, I think at the outset, there will be a follow-up email that provides these slides to you. Please be sure to subscribe to our Denton's commercial litigation blog, which addresses issues like this. And you can also check out our ESG solutions hub within our website for the latest updates. These details will also be shared in a follow-up email you'll receive next week with these materials. And with that, I just hope everyone here has a great week and a safe and joyous holiday season, and can take some time off to enjoy that season with loved ones. Thank you.